case number 107684, State of Kansas v. Tafoya.
May it please the Court, I'm Heather Cessna with the Appellate Defender Office here on behalf of Mr. Tafoya, and I would like to request 3 minutes for rebuttal time, please.
3 minutes is granted.
Thank you, Your Honor. I think we're here today this morning on a relatively narrow question as to whether or not a remand under State v. Copes on a DUI fine constitutes a resentencing, and in this case then whether or not, if it's a resentencing, my client's entitled to relief under State v. Reese. The Court of Appeals based its denial of relief on the mandate rule, finding that essentially the mandate in this case did not justify giving any jurisdiction to the district court to call this a resentencing. And I would like to just point out that the actual opinion from the Court of Appeals specifically states, as to the DUI fine explicitly, that the DUI fine was vacated and that the case was remanded for resentencing. The only
Could your client face, let's say at the original sentencing here, and he was sentenced as a fourth, I believe.
Yes.
And let's say the district court at sentencing imposed a 90-day sentence, or did the year and then 90 days, and then did the same thing with a fine and sent back to determine whether or not community service, so there's been alternative ways to pay the fine. Could he have imposed a year sentence on your client? Would you be sitting there saying that could happen?
I mean, I think that if this is a resentencing, then it is always possible. I mean, I think there's questions of vindictive sentencing at that point, potentially, or something like that could be made. But I mean, I think certainly the range would be open.
So your position is that could have occurred here, that since it is a resentencing, that just opens it all up, and your client could have faced 9 more months in jail as a result of this, in this scenario.
I think that that's certainly a possibility, Your Honor. Our argument specifically, I know that in Copes, one of the things that I wanted to address this morning was, I know in Copes this court has made a distinction between the amount of the fine versus the method of paying the fine, and our argument under Copes is essentially that even if you're just talking about the method of the fine, the consideration of the method of paying the fine and whether or not the alternative method of paying through community service under the DUI statute is available necessarily depends in part on the amount. And so under a situation like this one, our argument would be that even though the court explicitly in this case did not find that the minimum force times DUI amount was erroneous, that under Copes and the method and the consideration of the alternative method of payment would open the door enough that my client would be essentially allowed to argue the relief under Reese, which would in this case make his first time or fourth time DUI go back under the look back period to essentially a first time DUI.
Is the fact that this was a mandatory fine make any difference?
I think that it certainly plays into the fact that that in the consideration of the ability to pay the fine through community service, I think it helps that the amount of the fine being a mandatory $2,500 versus what would have been under the first time DUI plays a big difference as to whether or not when the court is considering the method of paying through community service. I mean, obviously that's a much higher amount than it would be under the first time DUI, and it is mandatory under that circumstance. So I would say it plays into it.
And what about the order of remand? Because it is a mandatory fine, we know that on remand it's not going to be affecting the amount of the fine. Does that leave us with a clearer indication that the Court of Appeals opinion was only remanding for the court to look at the method of payment?
I would argue that the Court of Appeals remand was pretty explicit. It said that the fine was vacated, and specifically to the DUI fine. There was only 2 things that were vacated in this case, and this was a direct appeal from a jury trial, so obviously there was a lot of different issues that were raised in the direct appeal. But the only two things that were vacated at all in this case were the two fines, the driving while suspended and the DUI fine. And the court, even in making the Copes finding in the Court of Appeals opinion, explicitly said it was vacating that fine. So our argument is that when it went back to, under the plain language of the Court of Appeals remand, that the district court, because the fine had been vacated, essentially had the authority or jurisdiction to consider implication of race under those circumstances when it was considering the court's ability to pay, or the defendant's ability to pay through an alternative method through the community service. So I would argue that both the mandate from the Court of Appeals, and I would say this, if this court is concerned that somehow the mandate of the Court of Appeals was erroneous in indicating that the fine being vacated as to the DUI fine was concerning, I would say that even if that's otherwise concerning to the court, that certainly the state had the opportunity to appeal that language and did not do so, and so that language is now part of the case law in this case.
It seems to me you're mixing. There were two different places. In one part of the opinion, it said the fine must be vacated and the case must be remanded for reconsideration of the method of payment in light of Copes. Mm-hmm. That doesn't say anything about resentencing. But then later it says sentence vacated and remanded for resentencing rather than fine vacated. So
Well, the only two things that were vacated were the driving while suspended fine and the DUI fine. So the only thing that this was remanded for was the vacation of fines. And our argument is that that the fine as part of the statutory DUI scheme is part of the punishment in this case, it's part of the sentence. I don't know how you can go back and vacate a fine and then reimpose it without it constituting some kind of a resentencing.
So you're not arguing that the final directive, sentence vacated, remanded for resentencing, means anything particular, that that's a mandate. You're talking generally that if the fine is vacated, that vacates the entire sentence. In other words, this case is not different than another case that didn't say sentence vacated.
Yeah, I mean, I'm arguing, I think that there is sort of three different places where the court made findings. That after the DUI fine, they said the fine was vacated and it was remanded under Copes. And then after the driving while suspended fine, they did say that fine was vacated and that it was remanded for resentencing. And then the final order of the court was that the case was, the sentences were vacated and it was remanded for resentencing. Our argument is that the fine language in the Court of Appeals opinion that said that the DUI fine was vacated was specifically would have required a resentencing at that point, because I don't know how you can reimpose a fine without it constituting a part of the sentence and becoming a part of the and that this hearing would have been something other than a resentencing on the DUI fine specifically. And so I think to the extent that they didn't say in that first part underneath the DUI fine that it was requiring resentencing was neither supportive or not supportive of our argument, since they vacated the fine. Does that kind of explain my answer? And it's a little convoluted. And certainly the language here is a little confusing, but I think it still benefits our client to the point of being able to get relief under Reese, and then that would make it would open the door enough that the court had the jurisdiction to consider Reese and would be required then to use the look-back period that changes this from a fourth-time DUI to a first-time DUI. Based on that, we would ask this court to remand this case for resentencing once again.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It's our position here that the district court did not have jurisdiction to resentence the defendant pursuant to that amended DUI statute, because the remand here was limited to the method of payment of the fines in this case. It's also our position that the court...
What did the Court of Appeals panel mean when it said, quote, sentence vacated and remanded for resentencing, end quote?
I would admit that they do say fine vacated and they use the term resentencing.
No,
however,
they say sentence vacated and remanded for resentencing. That's a direct quote.
Yes.
At the end, which is the directive to the district court.
And our position is that while they use that language, as the Court of Appeals here did, you need to look at the intent behind that language. And the intent here in the mandate was for the manner in which the fines were to be paid, was for that to be looked at again. And that the remand was regarding that. The intent behind the remand was not for a full resentencing. And I would agree that if that was the case here and the district judge decided upon remand to change the DUI, the jail sentence on the DUI, the punishment, I think we would also be here on that. While they say that that could happen, I think they would argue the opposite, and that that's not what the intent behind the remand here was. So it's our position that this remand...
How do you know what the intent of the remand was? Can you point me in the opinion what specifically you're relying on?
I would point you to the analysis of the COPS analysis for the DUI fine, and then the language regarding the driving while suspended fine, and where they are directly discussing the manner in which those fines are paid. That was the issue.
So it's that substantive discussion that the Court of Appeals undertook, and then the conclusion that there was to be a reconsideration of the manner of payment.
Yes, that's what we would look at. And I believe that's what the Court of Appeals below, when this came to them, I believe that's what Judge Powell looked at when he said the district court's only charge was to determine whether Tafoya would be allowed to perform community service in lieu of his DUI fine. At no time was Tafoya's DUI jail time or fine amount ever vacated, and under our mandate, the district court was prohibited from modifying them. And I think it is also important to note that this was a mandatory fine under the statute, and the fine amount, I don't believe, could be reduced. And I don't believe that argument prior today had been made that under COPS, that fine could have been reduced. The district court was charged with simply looking at the manner in which to pay that fine, and that's what it did here. So if there are no other questions, it is our position that what the district court did was proper in denying defendant's motion to resentence under the amended statute, and as well the Court of Appeals was correct in affirming the district court, and we would ask that they both be affirmed.
Any more questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
I didn't have anything else to add to that if the court doesn't have any additional questions based on the state's argument.
Any more questions? I see none. Thank you, counsel.
Thank you.
We thank you both for the arguments this morning. Clerk will take this matter under advisement.